Excited Utterance, the Evidence and Proof Podcast, Episode 176, Mary Fan, AI Enhanced Evidence. Welcome to Excited Utterance. I'm your host, Alex Nunn, from the Texas A&M University School of Law. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence and proof. We bring virtual workshops to you throughout the academic year. Joining me on Excited Utterance today is Mary Fan, the Jack R. McDonald Endowed Chair at the University of Washington School of Law. The topic of my conversation with Mary is her awesome new paper entitled AI Enhanced Evidence, which is forthcoming in the Boston University Law Review. Now, it will come as a surprise to none of our listeners that AI is currently having a heavy influence on pretty much every aspect of society, from corporate work to computer coding and, of course, to the law. And Mary's paper does a fantastic job specifically of looking at how courts are responding substantively to the emergence of AI-enhanced evidence. How are prosecutors using artificial intelligence to enhance photographs? How are defendants using artificial intelligence to provide exculpatory evidence? And how are courts responding both to prosecutorial and defense use of artificial intelligence? A really fascinating topic and one that's only going to become more important. I hope you enjoy my discussion with Mary today. Mary, welcome to Excited Utterance.
Alex, glad to be here. Thanks for doing this.
So your article opens with two really interesting cases where AI, artificial intelligence, was used to enhance or improve evidence. One of these instances had the defense using this AI, and the other had the prosecution using this AI technology. And the outcomes of those two cases were quite different from one another. So can you tell our listeners, maybe to kick us off, what happened in each of those cases?
Yes, absolutely. I start with a tale of two crucial AI-enhanced recordings for deciding a person's fate. And I do this because it captures the whole overarching theme that's motivating this project. It makes me passionate about it. So let me tell you first. The first recording in this pair was central to a claim of self-defense, but it was excluded even though an eyewitness could have testified as to whether that recording fairly and accurately showed events. Now, the second recording, in contrast, was pivotal to the prosecution, sending a mother of two to jail for life without parole, even though no eyewitnesses could testify about the accuracy or fairness of that recording, because it was so bad that even the police who made it couldn't figure out what was being said. And the tech company itself boasted that this was the first time its new technology debuted in court.
Super interesting. So we have one side getting its kind of enhanced evidence excluded, and the other side getting it admitted. So kind of a core tension that we're building up to. But before we dive right into that core tension between hey, who's getting their AI technology assisted evidence introduced and who's not, and what's the reason for the discrepancy, let's really set the stage here. So looking historically, of course, this is not going to be for artificial intelligence, but for other types of technology, how have courts traditionally handled, let's call it technologically advanced evidence? Things like, let's say, surveillance video that's been brightened by a computer or maybe sharpened images. And what are the main pathways for getting that admitted?
So customarily, evidence rules, they're flexible. They offer multiple avenues for enhanced evidence, if authenticated, to come before a jury. I'll talk about three main avenues. First, technologically enhanced evidence can be admitted as substantive evidence, if authenticated through myriad ways. There are myriad strategies to authenticate, as we know, subject, of course, always to Rule 403 balancing, which is tilted toward admissibility of the probative value versus any risks, such as unfair prejudice. So that's one avenue. An even broader route to get this evidence admitted is admission to what many of us call demonstrative aids from the olden days, but Rule 107, Federal Rule 107 now calls an illustrative aid. And this is not admitted as substantive evidence, but it's instead used to assist in understanding other evidence, like illustrating a witness's testimony. Avenue number three. Another way technologically enhanced evidence can come in is as a basis for expert opinion testimony. There, the court would apply the usual expert scrutiny and reliability rules, depending on if you're a Daubert or Frye jurisdiction for expert evidence. But even then, courts have not been overly searching in their scrutiny.
It's funny that you mentioned Rule 107 for demonstrative aids because I feel like I have an issue with that rule. Not at all because of anything to do with its content, but because in I think like one or two of my old articles, I proposed a new Rule 107, and now those articles seem really dated because there's now an official Rule 107, as you said it, for demonstrative evidence. So it's really mooted my past articles, but what can you do? But let's talk about that category though, like demonstrative evidence, illustrative evidence, because it seems like that category really can get stretched pretty far by a creative attorney. And you actually, in your paper, if I recall correctly, discussed some cases where parties got really creative with this category in particular. So what exactly did that look like?
Yeah, I'll just give you two examples, right? These stories are so powerful. It's really interesting about how this illustrative aid category gets stretched pretty far. So these cases use the term demonstrative aid, but we all know if you're operating in a Federal Rule 107 world, we call it illustrative aid. So one is out of California called People v. Hung Trang. It shows this judicial permissiveness in getting this enhanced evidence through the door as an illustrative aid, even in a place like California, which actually follows more restrictive standards for expert evidence based on newer novel scientific techniques. So this is another fight case, a fight in San Diego, and the key events of the fights and the attack on the victim were captured by a series of cameras. This is in the San Diego's gas lamp district, which if you're familiar, there's lots of businesses, lots of tourists. So you've got cell phone videos, you've got surveillance cameras, a lot of images, and that's what we're going to see in a lot of cases these days. So what does a prosecution do? They introduce an expert forensic video analyst who just takes all those videos, all these myriad sources, and just kind of tells his own story with a chronological sequence. He's tracking the key players using, in this busy, chaotic scene, he's using colored arrows across the videos, and this is a lot of messy videos. So he's claiming the people are who they are, doing things like tracking their clothing, their feet, etc. And the defense is like, it shouldn't come in. It's basically, they claimed it was doctored, but they're basically saying this whole story, this video story you've created should be coming in at least under the heightened standard for Kelly Frye, which is this famously restrictive Frye standard for expert evidence to illustrate expert evidence. But the court actually said, no, we're just going to apply the usual flexible rules for demonstrative evidence. Again, illustrative aids is what we call it today. They said just common sense, it's not a special method, etc. So it comes in, despite this jurisdiction with restrictive rules. I'll give you another example, a second story out of a different jurisdiction, because it's also kind of pretty egregious. So case called State v. Denton. It involves this trial. There's a charge for attempted kidnapping and robbery of a person who was just jogging along the highway by two men. So she says that when running, these two men got out of the car, ordered her to get on the ground. She ran away. She found refuge in another car driven by a witness. So talk about sandbagging. On the last day of trial, the prosecutor announces, oh, we want to introduce a computer animation to illustrate who was where and when during these events, which, by the way, of course, the defendants contest. So the animation is created by a police officer, and he had no eyewitness knowledge, no firsthand knowledge. He's just telling the government side of the story using an animation of all the key players based on his review of police reports and out of court conversations with a bunch of different folks and witnesses. He had no personal knowledge. The defense objects to this animation, which the prosecution just says is illustrative. They call it, again, demonstrative evidence. Of course, the defense had like a whole bunch of other potential objections as well. But the trial court says it's really convincing, it's super sophisticated, it's obviously going to wound the defense, but even though you didn't give notice, and even though it's really impressive and very persuasive, you can go ahead and play the animation. And that because it was an illustrative aid, it's not even available in the record on appeal. But in this case, this was so egregious that here on the appellate court found it to be prejudicial error. But so again, just showing how incredibly cautious this concept can be and how it can even be overstretched.
Perfect. So that's the category of demonstrative or now illustrative aids. Let's turn to a category that you mentioned earlier and you touched on a little bit as well previously, which is expert basis, or when an expert is actually relying on enhanced evidence to form their expert opinion, say like a forensic conclusion or something. And we know under the federal rules of evidence and case law, hey, courts are supposed to employ a stricter standard here. But you actually found a case where even the scrutiny for when this enhanced evidence is used as part of an expert basis was pretty superficial. So tell us about that.
Yeah, I'll pick another example that are coming out of the courts. And I pick an example out of Washington state because my opening story about the exclusion of key defense evidence also comes from Washington state. But in this case, same state, it involves the admission of prosecution evidence and flexible deferential approach that they took in the admission of key prosecution evidence. So what is it? It was computer enhanced digital forensics to identify the murderer of a student who was found in her apartment. She was murdered. There were bloody handprints visible on her bed sheets. But the problem was that the contrast between the prints and the bed sheet, it was just not strong enough for the latent print examiner to discern the minimum of 8 points to make a positive fingerprint identification. So investigators took the chemically treated sheets to an expert in enhanced digital imaging. So this expert uploaded the digital photos of the sheets, used computer software to filter out background patterns, dialed up the contrast, and then the police go back to the latent print examiner and show the examiner these enhanced images. And now the examiner finds a sufficient number of points to opine that there is a match to the defendant. Well, this is, obviously expert evidence, and frankly, the procedure is a bit unorthodox, right? So, in Washington applies the more strict Fry standard for new or novel scientific evidence requiring general acceptance in the relevant community. So, there was a Fry hearing about this fingerprint evidence. And of course, the challenges about this kind of unorthodox computer enhancement that is the basis of this damning evidence, the fingerprint match. So the prosecution, we're going to get into this more, but prosecutors are repeat players. And they often can have experts. You'll often see an expert, very highly credentialed, lots of experience. They'll appear in multiple cases, even in multiple jurisdictions. The prosecutor had like this arsenal of experts, as well as journalistic articles to support the digital enhancement. Defense, and we'll talk about this more, was under resourced, didn't present any witnesses, contradicting literature. It kind of just didn't present much. The trial court goes on and admits that match evidence facilitated by the digital enhancement. And very importantly, for the contrast I'm trying to set up in the article, in this case with the government evidence, the court didn't delve into the specific software used in the case. What was the package you used to do the tweaking of the images? They just said generalizing this general abstraction about fingerprint latent examiner processes. They say it's good enough to pass the test. So you're seeing a different level of scrutiny, even within the same jurisdiction, applying the same test. And I think it's just quite striking, the different intensity of scrutiny.
It is such a fascinating point, particularly because it's within the same state, as you know. You just did a fantastic job of recapping what I think is the Hayden decision, where again the prosecution's introducing this AI-enhanced fingerprint match. Courts, let it in with minimal scrutiny, we'll call it, which is the traditional, to be fair, reaction to demonstrative evidence or illustrative evidence, or even evidence that it serves as the basis of expert testimony. Courts, pragmatically speaking, have been somewhat lenient about it, at least. That's historically been the case. But that's changing, at least in one noticeable area. And that's something that you mentioned at the top of this podcast. And it's what really sets up the contrast between this treatment of prosecutorial evidence and the treatment of defense enhanced evidence. So, what is the case where we see very similar use of enhanced evidence, but not by the prosecution, but rather by the defense?
Sure. Let's go back to the case where the defense wants to use enhanced evidence. This case where the defendant's name is Joshua Palooka. He is claiming self-defense in the fatal shooting, rose out of an altercation, out of a fight bar at night. So bottom line is the defense's main claim was self-defense. And he claimed that he and his buddy, they were retreating, and there was an angry group, and the angry group surrounded him and assaulted him. And that's why he was like kicked to the ground. And to defend himself from this group, he shot. Okay, so to prove his story, because it's him versus some other members, survived members of the group, to prove his story, he sought to admit images from a surveillance camera footage, as well as cell phone videos that were shot by another bar patron who happened to be there. This cell phone video was actually posted on Snapchat. Now, keep in mind, this is at night and there's people in motion. Again, it's chaotic. It's maybe a little blurry, but the defense is saying, hey, look at this picture. It's showing two people beating the defendant, Mr. Palooka. And they actually shove him. He's hurtling over onto his back. He's hitting the pavement. His feet are flying up in the air. And the defense also claims that there's someone shouting there's a gun right before he fell and started shooting. So that video, the bystander video, especially the cell phone video, is crucial for the defense because the bar surveillance cameras can record after the shooting and before the shooting, but they had been moving. And so mainly it came down to that bystander recording. So the defense hired a video production editing professional who used this AI powered video enhancement tool from Topaz Lab, which has been used by video editors, film studios, creative pros. It draws on a proprietary machine learning method that can add greater pixelation to make videos clearer, brighter, smoother. In the article, I actually show the contrast, and you can see, I put that in, it's useful because I actually argue you should always see the original. And when you see the original versus the enhanced, it's obviously much clearer, but also the images look very much similar in terms of positioning and whatnot to the original, albeit the original is blurry. So bottom line, the prosecutors say that this enhanced video is inadmissible. They say this Topaz Labs tool has to meet FRI standard, the same FRI standard I just talked about. And so unlike in Hayden, the case we just discussed about the digitally enhanced fingerprint match, where the court let it in, the judge in Palooka's case basically just really dug into the specifics of the Topaz AI technology. And bottom line, instead of just allowing the defense to authenticate the video, because it was shot by a bystander who was there and could have just authenticated it, the judge conducted a FRI hearing. Bottom line is he credited the government and said that this Topaz AI technology, it uses these machine learning algorithms. They haven't been peer reviewed. They're not generally accepted. And he bars this key defense evidence.
So, yeah, it's really interesting in the sense that what I'm wrestling with as I'm listening to your description of these two cases is not just the outcomes differing between evidence offered by the defense and evidence offered by the prosecution, but it's also the level of scrutiny, it seems like. The one case, it's very cursory, it's very superficial analysis for the prosecutorial evidence, which relied heavily on AI enhanced evidence, and yet then we have the defendant relying on AI enhanced evidence, and all of a sudden the scrutiny is ratcheted up. So, is it fair to say that this distinction between the treatment of defense offered AI evidence and prosecutorial evidence is generalizable at all? And what I mean by that is not in the sense of like, an empirical finding where we're really diving in necessarily and declaring definitively that there's a distinction in treatment, but more broadly, the normative sense, does it tell us anything about who really bears the costs of heightened scrutiny in this new era of judges skeptical of AI enhanced evidence?
Yes, I do believe so. And there's absolutely, we'll talk more about future work. There's absolutely, I think, important future empirical work to be done on this. But there's already some evidence by Innocence Project co-founder Peter Neufeld, Exoneration Project co-director Michael Reisinger. They actually, 6 years after Daubert, Mr. Reisinger analyzed state and federal trial and appellate court cases involving Daubert challenges, and he found that looking at this set of cases, he found that criminal defendants were far likelier to lose their Daubert challenges, whereas prosecutors were more successful in excluding defense evidence in a majority of their challenges. And then Peter Neufeld found that criminal defendants did no better in jurisdictions that abide by the FRI test. However you tweak the tests, you're seeing that defense have a more challenging time. So I also have given a number of trainings to defense attorney audiences. And so there's their work, and there's also just hearing what people see on the ground in courts. And obviously I'm doing trainings to defense attorneys, so I'm hearing a lot of what defense attorneys see, and their experiences today also bear this out. There's a tendency to look askance at the defense. The idea is this: the person's already criminally charged, they have their freedom at stake. So there's kind of a more skeptical scrutiny of the defense. You're already going in with more skeptical scrutiny of your evidence and its veracity. In contrast, the government is the big G. They're going in, they're repeat players. They are known to the courts. They come in under the imprimatur of the government. And so there's already, I think there's that imbalance in perception going in there as well. And of course, there's imbalances in resources. And I'll get into that a little more. There's huge imbalances in resources. The government's experts are, frankly, more impressive sometimes because they can afford to have experts who repeatedly testify in government cases. So they have much better track records of having more experience testifying in court, better track record of getting their expert testimony admitted. And so there's that too, imbalance in resources.
And a little bit of an advertisement here. She mentioned Michael Reisinger, of course, an Excited Utterance alum. You can go listen to his previous episode where we talked about the blue bus problem, but fantastic that he's also at the leading edge of this literature as well. An incredibly accomplished professor. And of course, no surprise to hear that he's done really meaningful work here as well. So, Mary, as you mentioned a few times, and something I wanted to follow up on, is kind of like the hot news in the evidence world right now, which is all the proposed changes to the federal rules of evidence to deal with AI. But you note that these reforms are currently targeting the wrong problem. They're really focused on deep fakes rather than the far more common issue of not wholly manufactured evidence, but rather AI enhanced evidence. So, help me and help our listeners really understand that distinction and why it matters.
Yeah, this is a very important question. What is the distinction between AI generated deepfake evidence, which is certainly preoccupying our nation, as well as spurring more judicial scrutiny and skepticism, as well as potential rules change proposals? So, what's the difference between deepfakes on the one hand and enhanced evidence on the other? So, there's a huge difference. Enhanced evidence generally, bigger tent, it's a broader umbrella. It involves practices that, frankly, we've been doing for a long time as trial lawyers, right? Evidence comes in and light might be blurry, the sound might be bad, there might be a lot of extraneous. Long before the advent of AI, we've been using technological tools to enhance and bring out the relevant details of evidence so that it's more useful for the fact finder. So an AI enhanced evidence is just the use of AI powered techniques to do what we've long been doing, which is broader universe of just enhancing the details, not adding new details, but simply bringing out the key details and reducing the background noise so that it's more useful to the fact finder. This is what this article is concerned about, is this broader universe that happens every day in courts, much more prevalent than issue in courts right now than the issue of deepfakes as evidence. Deepfakes is something different, but deepfakes, they're basically false. They're fake. They're generated by AI, and they're creating details that are not there. They're creating whole narratives that didn't happen. They're just fake. And that's very different than enhancing what is there, and so that it's more perceptible. And this is a huge distinction because the worry that underlies this article is that you're seeing the rise of fear over deepfakes, even though empirically, thanks to a lot of different things, such as ethical rules of responsibility among attorneys, thanks to a lot of factors, so far we haven't seen a lot of horribles with respect to altogether deep fakes in courts. I cited one or two examples, one by a pro se person, where there has been an attempt to admit a deep fake that was so obviously deep fake, the pro se person actually got sanctioned severely for trying to sneak this in. So, but we haven't seen much with respect to deep fakes in court, whereas logically enhanced evidence is a huge part of proving your case, as we've seen with the stories that we've discussed so far. So there's a lot of different forms that are being proposed right now, posed by different challenges that technology is presenting, right? So, and some of them are super needed, frankly, because, so for example, one thing that immediately leaps to mind is machine generated output. We basically give machine outputs. We don't give them the same scrutiny as human testimony. For example, Professor Andrea Roth has done very important work on this. And now we're seeing advisory committee on the federal rules looking at a new rule that would subject machine generated evidence to greater scrutiny. That's great. I'm not worried about that. What I'm worried about are reforms that might ratchet up barriers In the name of trying to keep out deepfakes, even though we're not seeing it right now very much in courts, what I'm worried about is trying to reforms that might ratchet up standards for getting technologically enhanced evidence, period, into courts, and therefore exacerbating the disparities in power and already the disparities in scrutiny that we've been seeing. And so let's talk about some New York legislation that would require basically expert testimony to get your evidence in court, which is expensive because you have to pay for an expert. But there's also some scholarly proposals to that same effect. So that's what I'm actually worried about.
So I'm going to editorialize a bit
Mhm.
here and make the claim that, AI, it's here to stay. I think that its use has only become more prevalent. Some people might disagree with me on that, and you can email me and we can chat and have a wonderful spirited debate about the prevalence of AI. But as AI becomes more and more common, I think that this issue you've identified, this resource imbalance, is really going to have to shape the court and judicial response to the admission of AI enhanced evidence, because it can't be the case that we have a battle of the experts every time that a party wants to introduce AI evidence, because that would create incredible costs for both parties that both parties can't equally bear. So, in light of perhaps the prevalence and the growing prominence, even still, of AI evidence, what's a better solution to handling AI enhanced evidence?
Yeah, I lean pretty heavily on ethical duties, which I think, again, is one of the reasons why we're not seeing, for example, deepfakes as much. So, leaning on that, I argue that rather than having this expensive expert witness barrier to entry, we should instead just allow attorney certifications that no generative AI was used, or if an AI enhancement occurred, that certification that that technology did not transform or add content to the original. And so the idea again is leveraging these existing ethical duties of candor. There must be a meaningful opportunity for the opposing party to challenge this, but they have to show factual basis for the concerns so we don't get the liar's dividend that Professors Grossman and Grimm have talked about. But the bottom line is we don't want a costly battle of the experts.
Awesome. So this has been such an amazing discussion, a really fascinating topic. You've laid out the traditional flexibility, the emerging judicial resistance to AI evidence, a path forward that protects the reliability of evidence without deepening unequal resources. So I guess my last question is one of just looking forward. What's the most urgent next step that you see in this area, and what's next for the literature? What future scholarship would help with this issue?
Yeah, I think there is definitely a need for fresh empirical work. I mentioned the important work of Peter Neufeld and Michael Reisinger. Excellent work, but a while ago, right? And times and technology have changed. It is time now to do some more empirical work to really look again to see if we're seeing inequalities in admission within a jurisdiction that is subject to the same rules formally. I think it's time for some fresh empirical work. I think there's so much to be done, but that's one of the projects that leaps immediately to mind. So thank you so much for this opportunity to share.
Yeah, Mary, this is a great discussion, a great paper. Thanks so much for coming on Excited Utterance.
It's been such a pleasure, Alex. Thank you.
So, when it comes to artificial intelligence, you will find very few people who lack an opinion. Some, particularly those residing in the tech space, if you follow that area, predict a technological revolution always just 1 week away. A super intelligent AI is going to be released that is fundamentally going to shape or reshape society in a moment. On the flip side of the equation, you have individuals who discount AI as a complete fad. This is just a technological boom like cryptocurrency or NFTs or even the internet boom early on. Yeah, sure, there's like a useful product underneath all the hype around AI, but it's not going to have a material effect on society. So, where do I stand on that continuum? Well, as many of you know, technology is a bit of a hobby of mine. I have no formal training in coding or in computer engineering, but at the same time, it's always been a passion of mine dating back, decades at this point. And those hobbies have led me to a point where I'm staying up to speed on the leading edge, the frontier of AI design and development. So that means I am spending far too much time looking at the claims of corporations like Anthropic, OpenAI, XAI, Gemini, and I'm also looking at independent papers, benchmarking papers, to see the capabilities and the skill of AIs. Where are the areas where AI thrives, and where are the areas where AI currently underperforms? And so I have a pretty confident take in this sphere. And that is that both sides of the debate are currently correct in a way. So, as it stands, AI is a useful tool, but it has many flaws. There are problems of misattribution, hallucination, just inaccuracy that's somewhat insidious, and that it often takes a trained eye to see that, hey, this output from a seemingly polished AI actually has problems. At the same time, the trend line is very, very clear. And it won't be long, and here I'm talking about a time scale of maybe a decade or so, until we do have a super intelligent AI. An AI model that can accomplish any task on a computer better than a human could in a fraction of the time. And whether you agree with me on that forthcoming preview, or even if you're just willing to entertain the hypothetical, we should think deeply about how this is going to influence the law, and particularly evidence law. What will not happen, I think, for generations is any sort of huge upheaval when it comes to evidence and proof. Our legal system is intentionally slow moving. There is a lot of inertia and cultural legitimacy around proceedings and procedures that have been around for centuries. I mean, many of us talk about how the federal rules of evidence are still stuck in 1975 precisely because, well, if that version of the federal rules of evidence still has legitimacy, there is not a need for a revolution. So, in our lifetimes, my take is that there won't be any sort of huge upheaval. We're not going to have AI judges, we're not going to have AI juries, we're not even going to have AI attorneys. But what we certainly will have is more of what Mary has identified here. More situations where prosecutors, detectives, defendants, and their attorneys are going to increasingly rely on AI, not just for legal arguments, but also for the production and the presentation of evidence. And I think the time to start thinking about what our legal system should do with that evidence is now, before it becomes a problem, rather than later trying to play catch up. And for that reason, I loved Mary's paper today, forward-looking and considering the ramifications of a problem that is only going to become more and more severe. Certainly, Mary has given us much to think about concerning the future of evidence and proof. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The producer is Ed Chang, and the production editor is Anirudh Morella. Additional assistance was provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Alex Nunn, and I hope you'll join us again next time when we take on another work in the world of evidence and proof.